following interview is with Judge Kathleen Rodenberg of the Clermont County Domestic Relations Court. The purpose of this video is to help you decide whether or not you would like to have an attorney represent you in court. What are the benefits of having an attorney represent you in court?
You're basically going into a legal action, and if you're not an attorney, it would be like trying to play baseball, never having seen it played before, not knowing what the rules are, not knowing what the objective of the game might be, and your chance at success in that situation would be fairly slim. And it's the same thing with representing yourself in a court case. It's always best if you're coming to court to be represented by counsel, just as it's always best to be operated on by a doctor if you're going to have an operation, or have your hair cut by someone who's trained to cut hair if you're going to cut your hair. But I understand the reality of it is some people just simply cannot afford it, and there are limited services available for them to obtain counsel at either reduced or no cost to them. So sometimes they have to. But what the pro se, we call them pro se, that means they're representing themselves. What the pro se litigant has to keep in mind is that they are held to the same standards, the same rules as attorneys are in presenting their case. So the fact that they may not know what I mean when I sustain an objection is not an excuse. I can't guide them through presenting their evidence. I can't help them in getting their evidence out. And I can't train them in how to present the evidence properly. If they're representing them, if a person's representing himself or herself, then he or she needs to figure out how to present all the information they want me to consider in a way that it would be admissible.
How can someone find the legal services that are available to them?
If it's a divorce case, legal aid provides counsel in very limited situations. Like all other public agencies these days, the funds are very tight, and so they have to reserve the money that they have available and the attorneys that they have on staff for cases that fit most with their mission as a legal aid society. But you can certainly contact legal aid and see if they'd be willing to represent you if you fit into their requirements or their guidelines for eligibility for representation. The other choice is a lot of bar associations run programs where attorneys have agreed to accept a case either at a reduced fee or even at no fee at all. And so you can contact your local bar association, explain to them, where you are, what court you're going to be in, and ask if they have any programs that might qualify you for that type of assistance. But again, it is very difficult to find an attorney because representing somebody in a divorce case can be a long and arduous process, and it's difficult to find attorneys who can afford to do that without charging anything.
If you decide that you would like an attorney to represent you, there are two organizations you can contact. First, you could contact the Legal Aid Society of Greater Cincinnati. Their website is www.lascinti.org. Their telephone number is 513-241-9400. Or you could contact the Lawyers Referral Service at the Clermont County Bar Association. They're located at 270 East Main Street in Batavia, Ohio. Their telephone number is 513-732-7109. Or you could email them at cclaw@cclla.org. Can I represent myself in court?
Legally, you can represent yourself. There's no requirement that you have an attorney. But as we spoke about at the very beginning of this conversation, when you are representing yourself, you have to figure out what facts are important, what facts are irrelevant, and how to get those important facts that support what you want to have happen in the case before the judge or the magistrate, if the magistrate's hearing the case. And that can be a pretty tricky process if you don't know where to even look for the rules of evidence or the rules of civil procedure and so on.
Will having an attorney affect the outcome of my case?
The case is decided on the facts. So it doesn't matter, having an attorney or not having an attorney does not determine what the facts are. But having an attorney or not having an attorney may determine what facts get presented. And so that's the type of effect that it would have. It's not as though I see parties come in here, one side has an attorney and the other one doesn't, and so I side with the attorney on whatever they're asking for. It's not that way at all. But I will tell you that that attorney is going to know more than the person who is not represented about how to present the pertinent facts to me. And then I'll decide the case on the facts. So if the attorney presents facts that support the attorney's client's way that they want the case resolved, and the other party doesn't present facts to either overcome that or to contradict it or to support what they want to have happen, then I'm going to order it based on the facts that are presented. My order will be determined based on the facts that are presented. So having an attorney or not having an attorney isn't what determines the outcome of your case. What determines the outcome of your case is what evidence you present to support your position. Having an attorney will help you accomplish that step in getting your evidence before the court.
Can a friend who is not an attorney represent me?
No, we can't allow people who are not licensed to practice law in Ohio represent a party, even if it's your best friend and you think he's the smartest guy in the world and he went through a divorce himself a few years ago and he knows all about it. That would be practicing law without a license, and we cannot allow that to happen in the court. So the only person who can come into court is either the party himself or herself representing himself or herself, or the party with representation through an attorney licensed to practice in the state of Ohio.
What does the judge do during a domestic relations case?
My job is to maintain the orderly presentation of the evidence, to listen to the evidence that's presented, to be familiar with the rules of evidence, the rules of civil procedure, the case law dealing with these issues, and to then make a fair decision based on the admissible evidence that is presented. What I do is I stand through the hearing, but the party will testify from this box down here typically, or any witnesses they bring in, and they'll be asked questions by each side. They each get a chance to ask questions, and they can ask again, or recross, redirect. And once that witness is finished, that witness leaves, and then they bring the next one in. And there may be documents that they present. So it's my job to go through those documents, to listen to that witness testimony, all of the evidence that's presented, and then to make a fair decision which is equitable to the parties and in the best interest of the children when there are children involved. As they're testifying and presenting evidence, I'm taking notes. I take my notes on the computer so that I can be typing what's going on and make the notes that I need to know to be able to decide the case later without having to listen to the whole trial again. But I can also keep an eye on what's going on out in the courtroom. So I can see if somebody's making faces or rolling their eyes or mouthing threats to their spouse, which has happened on occasion. We try to keep that at a minimum. So,
If you have additional questions, please contact the Clermont County Domestic Relations Court. They're located at 2340 Clermont Center Drive in Batavia, Ohio. Their telephone number is 513-732-7327. Their website is www.domesticcourt.org.